Yes. Good morning, everyone. On behalf of Beyond Law CLC and ULS Chandigarh, Punjab University Chandigarh, I welcome you all to another webinar, but on a different subject. And more so, once we go for a Securitization Act, popularly known as Sarfaesi Act 2002, there are many new challenges after the COVID-19, and even otherwise, for some people, the Securitization Act has always been felt to be a draconian law. There are certain measures, and what is the journey about that? But before we call upon Honorable Mr. Justice KANNAN, as we popularly call him, he's a judge who has accomplished himself not only while penning down his judgments, but with his humane touch in the judgments, as well as if we meet him personally or on any platform. He has popularized mediation as one of this thing. During all these webinars, one thing we have learned, that lockdown may lock us inside, but the knowledge has no barriers. We have all weaved up together for the betterment of the knowledge, which not only the students, lawyers, and other professionals are latching up. Amongst us, we have Mr. Indra Pratap, who is the president of the DRT Chandigarh. He would formally welcome Honorable Mr. Justice KANNAN. And we also have amongst us Mr. Suveer Sidhu, who has been the former secretary of the Member Bar Council, and even otherwise his father has been the chairman of the Bar Council of Punjab and Haryana High Court and president of the bar. I call upon Mr. IP Singh, president of the DRT Bar, to welcome formally Justice KANNAN.
DRT Chandigarh Bar Association welcome Honorable Mr. Justice KANNAN, former judge of the Punjab High Court Chandigarh on this platform. It's indeed a matter of pleasure and thank you, Mr. Vikas, for organizing this show today again, which is continuing for more than a month, and all of us are being enlightened. And I welcome Honorable Mr. Justice KANNAN, of the former judge of the Punjab and Haryana High Court Chandigarh, on this platform. It is indeed a matter of pleasure and privilege to have Justice KANNAN for the second time on this platform within a period of 1 month, which shows how much love and affection he is having towards the lawyers of this region. Everyone is aware of the good reputation of Justice KANNAN, who was known for his honesty and integrity. He has got a judicial approach. He is a down-to-earth man. He would go to the root of the case to decide the real issue while deciding any matter. And he had no consideration of any face value while deciding a case. For example, whether it was any senior or a junior lawyer who was appearing before him. And he never gave any importance to any sort of like the lobby which was going on here in the High Court as uncle judges, which I will say. So I am very much sure and confident that the legal fraternity shall be enlightened and enriched by the experience of Justice KANNAN on the subject under issue today. So I hand over to you to please enlighten us on this issue. And the DRT Bar Association, mostly the participants are there. They will also be enlightened by your this seminar today. Over to Mr. Vikas for further.
So, Justice KANNAN, it has always been a pleasure hearing you not only in the court while you were penning down the judgments and dictating the judgments, and meeting you in the court on a different platform outside the court, and now on these virtual platforms. It's always a pleasure, and to hold you for a long, it will be an injustice because the participants are just willing to hear upon you. Thank you, sir.
Lovely to be back with you all. Dear Mr. Vikas, Mr. IP Singh, and to all of you there. I'm so excited to be associated in some way or the other with Chandigarh Bar. You have been very special to me. And because talks to me about the COVID times, when there are truly stressful times for industry, person that borrows money expects the business to be run, expects profits to be made, repayments to be done. That is the way the whole economy goes. Not everyone that wants money has it, and therefore he has to secure from somewhere else and then put it. Not everyone who has money knows how to make it multiply. So therefore, banking and financial institutions bridge the kind of gap between persons who do not have the resources, but who are resourceful enough to start industries, how to keep it going. So from the point of view of macroeconomics, from how great plannings are made and executed, we need to understand this branch of law well. I had a thought thinking of my own association as a lawyer, did not understand the subject too well at one time for persons who had initiation to understanding security, enforcement of security under the Transfer of Property Act. The Securitization Act, the Sarfaesi as we say, brought giant changes, massive changes. So the understanding had to be completely different. And if anyone was sent to the Debt Recovery Tribunal from my office as a junior, probably I never did anything more than merely saying, take some more time. We don't seem to have defense. Let us try to take some time before the DRT, and then ultimately the case will be ordered. We'll take some defense, we'll deny everything because banks have all documents, and then you deny the loan. You deny that you signed with the knowledge of what it contained. So never really knew what was possible for a lawyer to do beyond taking time in courts. And changes kept happening because when DRTs initially to start with, they were guided only by the lawyers who was practicing normal courts. And therefore they knew that taking time, taking an adjournment is not a big deal. It always happens if you're engaged elsewhere and it is possible for you to say. And it didn't happen the way the Parliament envisaged that should work. So therefore there had been substantial changes. Two principal reasons how it came to be made was there were the banking sector was not doing too well. The industry had several requirements that they had to go to private money lenders who charge usurious rates of interest. And if there was security and there was an enforcement of security, if you know how things were happening, how much time it took in courts, it became very difficult for a person who would give credit to recover if there is ever a default. So this law came through some recommendations from committees. So I'll put through some slides, and we are going to be talking essentially about enforcement of securities. The Act contains several things, and it's just about 50, less than 50 sections, but then each section is quite complex. So therefore, the subject itself is not at all times a purely legal subject. It makes so much of it, employs so much of jargon from the banking sector, from the finance sector, from the capital markets. So we need to be introduced to certain concepts. And I'll right now go through some slides and share some screen with you. And I'm sure, like we at all times did, we'll have adequate time for questions and answers. Host is disabled from participant from screen sharing. You can't disable. Make it possible for Vikas for me to share the screen?
Yes, sir. It's been out.
Yeah. So
Yes, sir.
the enforcement of the security interest and making of banking and financial assets matter is how I envisioned the whole program for us today. And I'll give you briefly an outline about how I'll go. We'll run through quickly on the history of legislation, committee reports which made it possible. What was the previous inadequacy in the system of realization of security interest or enforcement of these securities? How do we therefore think of empowering the sector? This is one part. So I'm thinking of three segments. Second one will be the taking of possession of assets, which is the most crucial thing, which is when we see the orders of DRT put to place, or the DRT oversees what is happening, and recovery officers bring it there later when the property is going to be prime for putting up for sale. How is it all done? And the most important thing, I make it as a small subtopic for you, because at the time when possession is sought to be delivered, resistance to possession comes through persons who are not at all times seen at the time when any lending was made. So therefore, the persons who could take an obstruction, or if there is an obstruction under some color of law, it happens through tenancy rights, and therefore nature of tenancy, which will be relevant. And we are talking about asset reconstruction, the securitization and asset reconstruction. These are small technical expressions which I'll explain before we go into the enforcement of securities, because we need to understand that this law contains something different from what we are acquainted with under the Transfer of Property Act. For persons who are probably students of law, the young lawyers there, must know that they have a role to play more than merely arriving in the DRT and taking time, or merely these documents were executed by them. There is something else which they can do, and therefore they should know what some of the concepts which are underlining in this act. And I would think as a last, the performance, or what is the role of the DRT? What is the extent of adjudication which is possible? Is it merely an institution which, okay, see, everything is in order, yes, an order is passed. Take an award, enforce it, take delivery, possession of property, disperses the person who has availed of the loan, who is not able to pay. And how do we as lawyers do some work beyond taking time in court? While taking time and relieving the distress for a person who is unable to pay is fine, but then that cannot be a principal activity at all. And I have always a penchant for dispute resolution in the way that mediation takes place, as how Vikas introduces me already. So therefore, I will also have something to say about that in this scheme of very little used or seldom used provision, which we need to be really seeing. And that's how this may not necessarily follow in the same line, but this is how I plan to take you through. And to know that the legislation, it all probably started sometime in the year it was 1970s and 80s in USA, where house mortgages were a popular theme. And many persons, housing became a major activity in USA. And it became possible only by financial institutions lending money on the security of property, of the assets, or what they will give in order that a construction is made. The construction will also be a part of the security which is offered. So of a security which is going to be at an initial stage in an incomplete one, later to grow, all that was how it was conceived. Later, the Wall Street took it in some way. It cannot be only these securities. There should be other type of assets as well. Assets, the financial assets are what the Wall Street was very familiar with, and they used these financial assets for securitization. So therefore, this is how it started, and we had known issues of OT or mortgages, usufructory mortgages. We had known at all times. In Punjab, I have seen that it did not require any document, some entries there. in the revenue records would be sufficient to put a person in possession of what was very significantly different in Punjab. Why the Transfer Property Act itself was not extended except for a few provisions relating to sale and other things. And we're all aware of creating some security for a person who lends the money and enforcement of securities. But this act provided, the Transfer Property Act provided for enforcement through a civil procedure code. Civil procedure code took that as a very important piece, and therefore it made a separate provision in Order 34. And Order 34, among, if you will, practitioners of law will know that if property is brought to sale, if the hypotheca is taken to sale for non-payment of money, and the property is purchased, the purchaser was never assured of property being taken delivery of. All that was, if the mortgagor comes at the last minute after a sale takes place, and there is an application for reopening the case, restoring the case, preferring an appeal, and then even after the sale, it became possible so long as even after the passing of the final, so long as a particular period was not concluded before the delivery was taken. Any time before delivery, it was possible for a mortgagor to make the payment and then see that the mortgage is redeemed. So it was the terms of law were such that a security interest was at all times used for purposes which was not correct, which did not do full justice to a creditor. It did not also do full justice to a person who was prepared to stake his claim, purchase the property, put the funds in the financial institution, for the financial institution to take. And
could you come close? Sorry, sir. Could you come closer to the mic because there's some distortion of the voice. The voice is cracking.
Okay. Okay. If there is anything, please tell me now. So
kindly do not scribble on the screen. Otherwise, we will have to remove that person whosoever is doing that.
Yeah. So there are some. Yeah. So, this is how it started, and therefore the Transfer Property Act provisions were not sufficient. Order 34 Rule 5 itself was a kind of a disincentive for quick realizations, and the State Financial Corporation Act brought for the first time something more. And the financial institutions had the power to take possession of the assets and take over management. All that was possible through 29, 30, 31. And this was for a very small area of activity by financial institutions, which are the state financial corporations. So this did not include everything. And therefore, the government of India at the time had set up a committee, Narasimhan Committee it was called, that gave place to a very important role for RBI. How will the central bank control various constituents? It also talked about some method of understanding a non-performing asset. You know, if somebody borrows money from the bank, he doesn't make the payment. It is shown in the books of accounts of the banker as an asset. It is, the banker is entitled to realize it. And it's an asset. And it's more than 3 years, 4 years. It's because there is 12-year period where there is an enforcement of security. And then it is there for a long time. And it created a false picture. It would seem as though the bank has enormous assets. And in the way the balance sheet is drawn, it would seem like the bank is rosy in its functioning. It may not be at all. For it may be shouldering a heavy burden of lot of debts from persons who are not servicing the loans, and it is merely creating a false picture to the public and to even the financial institutions. So this non-performing assets, as to how it should be treated, and how do we characterize some assets as non-performing, was also what the Narasimhan Committee talked about. And it also recommended the entry of foreign banks. Foreign banks came in a very big way, brought with them also their investors, brought some kind of incentives. So therefore, it was to revamp a banking sector in a very big way and ensure also recoveries in some ways which will be different. And it contemplated setting up a separate institution for that. And that was what, therefore, gave place to the DRT, the enactment, a separate enactment which came for setting up establishment like a debt recovery tribunal. An exclusive tribunal came through the Narasimhan Committee recommendations. And it didn't seem all sufficient because, like I said, the DRTs, as they started working initially, they were just extended courts. They were happening the same way that institutions allowed for the usual manner of performance in courts. It did not improve the quality of adjudication or recoveries. So therefore, there was Andhyarjuna, a very popular lawyer, persons of the Supreme Court, a senior counsel of the Supreme Court from Mumbai. He had an important role to play during Keshavananda Bharati case with assistance given by him and Harish Salve to the great counsel, Nani Palkiwala. And he had, there had been a committee with him with about 12, 13 persons. And he contemplated, and the committee made a recommendation for a separate law for a securitization, which gave place to the Sarfaesi Act. And it also made important recommendations for certain changes in the way the DRTs functioned. So therefore, it gave place again to some important amendments to the law that established the DRT. And it advocated for the abolition of SICA, the Sikh Industries. This is again a tribunal which merely allowed for a company, it goes, and there is a provision contained there which will stay proceedings, and then there is a proceeding before the SICA, then you stay all the proceeding before any other court. So simultaneous proceedings were there before courts as well as before SICA. Nothing was happening. So he also said, now let us abolish it. And then this also gave an amendment to Section 28 of the Contract Act. So these were the various changes which Andhyarjuna Committee talked about. And what it gave place to the Sarfaesi, or what we are now concerned about, was the certain concepts. What is the security interest of what it creates? How is the security to be enforced? What does the securitization do? And then with the security, what must happen in order that you approach the DRT for enforcement of security? Or when you can take possession of the assets under Section 14, when you can issue notice under Section 13. So all these would require, the next thing must be the NPA. So the condition in order that you have an enforcement of security will be there must be a security interest. It should have become a non-performing asset. If it is still performance, if the loans are being repaid, there is no question of anyone coming suddenly foreclosing things and then coming to the tribunal or to the DRT or to issue notice for possession. And after that, the third one, which this is for enforcement of security, which is essential, is take possession and bring the property to sale. So these are the three stages which we will see now about the enforcement of security. And the other thing will be this an asset reconstruction, because whenever we're talking about Sarfaesi Act, there is a body, an institution which can take assets, which can take all the stressed assets. This is something like, you have some automobile, all old automobile shops where the old cars, dumb cars, you take it there. Why should anyone be interested in scrap? Does anyone ask? It doesn't surprise us, because there is always a market for recycling it. There is always a market for somebody who is interested in money, who is not able to secure. The bank is interested in securing its money back. It's not getting it. There is a person who is not paying. It's a non-performing asset. There is a reconstruction company who says, no, don't worry. I'll take over. I'll take it at a discount. You expect 10 crores of money? All right, I'll pay you 2 crores. You're good with 2 crores now. Whatever I'm able to secure, I'll take care. So therefore, the reconstruction companies truly are the companies which lend oxygen to the financial market wherever a fund becomes stressed. So therefore, this is how it goes. And in the manner of seeing that, we'll just see some of the concepts. I thought the definition itself in securitization is a kind of a complex definition, but just go through with me. This is something which we must know. If you have a section 2Z, if you read securitization, if you've understood, you're a great job. But then it is not always very easily understandable. So therefore, I'll tell you, give you some example. It's a kind of risk management tool. That's what they say of a securitization. This is associated with the default of individual assets, and the banks and financial institutions adopt this tool to minimize their exposure to risk. Just to illustrate to you, bank lends money to a person who purchases a car. Banks lend money to a person who runs an industry. Banks lend money to a person who is building a house. Now, these are monies lent with some securities taken. Let us say for house property is offered as security, or land is offered as security. There are securities which are offered to them. They have an exposure to risk of one person could be a genuine person who is unable to pay due to some difficulty in the market, his business failed. Another person's lost his job. Another person thought he'll be a defaulter. The banks have all the resources. What am I doing? If I'm not paying my money back, what will happen? So therefore, there are various levels of risk involved in any lending, isn't it? It's an obvious thing all of us understand. Now, this risk is now of an exposure of what I have. I make it available to somebody else who is prepared to pick that. And then that is done through issue of bonds. Then I say now, for you may have probably heard about hybrid varieties, or it could be just on capital bonds for something for infrastructure building. So therefore, depending on the type of lending which I've done to several types of loans which I've issued, I may secure all these assets of what I have in my hands of a right of enforcement of these securities. I will give it away to persons who are prepared to pick it from me and invest in those kind of securities. They will invest in those securities in undivided shares. We are acquainted, students of law understand undivided shares, the way the Mithakshara operates. It is a fluctuating thing. It may keep happening. It's an undivided interest which somebody, the asset reconstruction company, will pick it from you. So therefore, you have your various types of, there are mortgage-backed securities where securities are essentially driven through mortgages, which all of us understand. Or it could be on auto loans, credit cards. For instance, credit card, when a bank extends a credit to you and you are liable to pay the money to the bank, the money which it has lent, it is going to recover it from you with interest. That is an asset which the bank owns. So therefore, these are various types of assets which I create, which are secure. Security interest, it could be through immovable properties, through other financial securities as well. All these are various things which can keep happening. Now, in that, we will again know that there is a liquid asset and illiquid asset. Normally, we know liquid and solid. When we're talking about something liquid, then something is a solid person. We don't talk about solid assets. A liquid asset could be a solid asset. Liquid asset is an asset which is immediately capable of being converted to cash, money. Fixed deposit, for instance, it's a liquid asset. And it's a short term, within a short term maturity, if it has, it's possible to convert it to money immediately. The illiquid, that which is not immediately possible of conversion, it could be a real estate security, it could be shares also, but then they become truly liquid in these days. Illiquid is that which is not immediately converted in terms of money. We'll take it like that. This is how you normally see. Out of this, we'll also see another concept. The institution through which we'll see is reconstruction of financial assets. The asset reconstruction means, I've now brought it there as important definition. I thought asset reconstruction means acquisition of, just put that, I think it's, has gone away. The asset reconstruction is a kind of a financial institution which makes, it buys all these kind of securities, it invests the money there and then takes it at discount. That's what happens. Now, the concepts I said, which I will introduce you to, is securitization explained to you as to how it operates, where it can be even in a, one more illustration of what I can give perhaps is, supposing I undertake to build a bridge. There is a contractor, and in a contract with the government, they say now you build a bridge, you put your money, and then you can collect funds. You can collect, install a toll, and then collect the money, or it is handed over through the government to through some person who is prepared to take it as a concessionaire, and he collects the money on behalf of this person, pays the money who has built. So therefore, you have, he is now going to recover. Supposing he has invested in about 100 crores in an infrastructure building for the government. That 100 crores, he has to realize it through tolls, let's say like that. And it knows it's going to take a long time. It's going to take about 20 years. So therefore, I don't have the time. I want money immediately for the money which I've invested. There is yet another person who is prepared to buy that. He is prepared to take it from you and say, no, I'll stagger it. I can recover it over a period of time, because in his portfolio, he has several levels of risk which is exposed to himself. He knows this toll booth can generate, say, every month somewhere close to about 50 lakhs, let us say, on a highway. So therefore, he is prepared to see that this money can come in this time, in a span of 20 years time. That's fine for him, for he is putting his money in this, expecting it to secure to him about 200 crores. So therefore, that is his margin over a period of time. So therefore, that kind of a security where you share the risk with another person who is prepared to invest, he is prepared to take that. That is the way the securitization operates. And I also told you about the liquid assets and the illiquid assets, of how they have to do, their understanding is through how it is capable of being converted to money. Debt securities or those securities which are open debts which are created, and if they are offered as security, they are financial securities. Definition of debt, I don't think is necessary. We have it there. The non-performing asset also, I told you about non-performing assets. It's a standard asset, which is, when we are talking about standard assets, we are talking about an asset where there is fits and starts, a repayment takes place. It's not regular. That's a standard asset. A substandard asset, when we say a non-performing asset, where the repayment is not exceeding 12 months, it's less than 12 months, it's a substandard asset. And then it is a doubtful asset, where the repayments have not taken place for more than 12 months. Then you call it as a doubtful asset. Then you also call make reference to loss assets. Loss assets are assets where the repayments have not happened for more than 3 years. And that is more than 36 months. And there are willful default, where loss assets could take place due to various reasons. There could be a willful default, typically of what we hear from Kingfisher, of where you found the Malay was not paying back the money, and it had secured its loan through its own assets and things, but then the payments had been grossly irregular, and you realize that he had the funds, but he had a manner of stashing away in places where the banks could not reach. And therefore, it was possible for the person to be enjoying the benefits of all the loans they had taken, they had secured, he could secure, but still he was not paying. It was willfully, he thought, now let me not pay, what could happen, let us see. So that was an attitude, that was willful default. Therefore, you will find that the willful default happens in situations, and therefore the financial institutions or the government which extends some kind of packages don't allow this any benefit of tackling a repayment to a lesser sum to persons who are willful defaulters. It could take place on account of industrial crisis, typical situation of what you see during COVID. A payment may not be possible, the income is not coming, the workers are not making, they are not attending factories, and the factories are shut down. It could create serious problems. NPA could be on account of a recessionary trends in the market, a slow growth. And in some areas, for us in India, the metal, the real metals like silver, copper, then steel, all these, there had been seriously, the growth had stunted in a very big way because of several reasons. One of the reasons was also on issues of environment, whether we need to have this kind of mining industries became a very serious doubt. That there had been a lot of delays in sanctioning, granting licenses, and there was a lockdown, and there were problems like what happened in Sterlite, where the factory remains closed for various reasons. So that is one. Or where the banks themselves are very lenient in their norms. They flout the norms of what the Reserve Bank of India sets down, or what we probably know through Nirav Modi's situation, where today, a couple of days back, the information is the case is coming up there, and he has a similar defense like what Malaya has to say, that Indian prisons are not good, as though the prisons have to be palaces. And that is how they saw. And this is again possible on account of the lenient lending norms. There could be overrating sometimes. For instance, I'm told among other places, the Amtech batteries, they were rated very high. They thought it was a great company, but it became sick. They didn't repay. They fell into serious problems. So therefore, you have several reasons why asset become non-performing asset. So that's the way we understand, because that is a condition precedent for enforcement of security, that debt has become a non-performing asset, NPA. We just need to know. And in terms of how serious the problem in India is, our non-performing assets in terms of the total in 2017, total was 9.6% of all the assets. The non-performing assets was as high as 9.6% in India in 2017. I think in 2018 it went even higher. It's 10.4%. And China, for instance, which is a larger economy where they have large financial institutions which lend big time monies. They have the NPAs was probably the lowest. It's about 1% or something, just around 1%. And India records the highest, the second in the world. The first is Italy, that you can always, it's not always our way. When I was in Punjab, we used to joke, if anything is bad for us, we'll compare ourselves with Pakistan and feel happy. So it is not like that. Italy is bad. It's worse than us. They have 14%. And of the banks, the bank which shoulders the maximum problem of NPAs is IDBI. And IOB also, that IDBI has somewhere close to about 24.1% of all the assets of what it has lent are NPA. IOB is also fairly high, is 23.6%. Kotak Mahindra and HDFC, they have the lowest, and they have somewhere close to as low as 2%. Smart banking there. And SBI also has a lot of stress assets. They're above the overall average of 9.6%. They are about 10%. So I told you this NPAs can result on account of several situations. Several situations could be due to external factors also, such as what we are seeing. I'm giving to you this only in order for you to know that NPAs can result not necessarily only by a willful default. It can happen due to so many other reasons as well. And that is essential for us to know. And with this, I will just see now, apart from securitization, now I see that's just a minute.
Want the slide?
No, the slide is just
I haven't done it because once we are showing on the live on the Facebook, then you are not visible, and the slide also doesn't become visible. That is why I removed the slide. As and when you want, we will allow that.
I want the slide now. Yeah, now and then. See, when I'm not making the slide, probably you can put the slide back.
Right. Because on the Facebook, it's only showing the slide.
Yeah.
Yes, sir.
Now, see, apart from this, I said that something we need to know is the reconstruction company, which is not the face before us. In many situations, we see the bank there. The reconstruction companies play a very important role. Like I said, there are two sections which you need to know where you see under the Act. In Sarfaesi, you see, because that is how you'll find the Sarfaesi Act itself begins with section 3, 4, 5, the registration of reconstruction companies. That is where the emphasis is given, not the financial institution or a bank. Acquisition of rights of interest in financial assets, section 5 talks about it. There is a provision for exemption of stamp duty. How does they, therefore, they operate at 100 crores, 200 crores. There is an exemption from stamp duty, which is provided there in section 5. And the exemption will not be available if the acquisition is for a reason otherwise there for reconstruction of the company. And then the measures of asset reconstruction, that is talked about under section 9. The reconstruction companies have the ability to take over management. Stressed asset, they're not managing it properly, then it is possible for them to take an assignment of the debt from the financial institution, a banker, and then they'll be able to take over management of that. They'll be able to sell, they'll be able to lease or to reschedule loans. Whatever a financial institution can do as a principal lender, that the asset reconstruction company will also be able to do that. They can take possession of the asset. Because there are some exceptions there. They're taking possession. What is the level of interest which they must have? It can't be a minority interest. It could be more than 60%. There is some provision there which sets some limits. They also have other functions which are essential for its active engagement. Is they act as agents for the bank. They can take possession of the assets in section 13.4, and they can act. A reconstruction company can take itself the position of an agent from a bank and take possession. It can act as a receiver. It can manage things. So these are the other functions of the reconstruction company, and they are the ones which really engineer the recoveries. And yeah, the next slide for me.
Sir, we have allowed you. You can do that.
Yeah. Oh, I'm not able to do it.
Allow screen sharing. It has been allowed, sir.
Yeah, it's been allowed. I'm not able to push it through. It got stuck there because I have to go through some other.
So we've allowed it. Just try that. Okay.
Not moving for me though. I think I will go with another instrument. It's okay if it's not happening, but I thought it should come before I take over some director provisions relating to some decisions which have come about. Let's see, it's not working.
I will just cross check.
Yeah. Yeah, I got it there. The enforcement of security, this is where I see an important activity for us. Are you there? Am I audible?
Yes, yes, it's audible.
Yeah. The enforcement of security, there is a section 11. I said we are not using the provision much, and that's a major problem. Section 11, please read this. I want you to know, I said also that our engagement cannot be merely taking adjournments or taking time for making payments. There is so much else possible, I said. Section 11 is very important. It talks about section 11. It offers a scope for lawyers and mediators. It allows you to settle the DRT when the matter comes before them. It's possible for it to refer to that. Otherwise, a lender, bank, or a reconstruction company can itself resort to mediation. And what do we do at that time? If ever a problem comes to us of a borrower who is unable to pay, who comes to us, I already told you about what are all the activities for a reconstruction company. It can take over management, it can sell, it can lease, it can reschedule. So in all that, if we need to find, if somebody comes to us, don't immediately say, sir, I'm not able to pay now. I will pay, but there is no doubt it has become non-performing asset now. I'll pay if I have one more year, I'll pay. Don't take merely responses from your client as saying 1 more year, 6 more months. Try to go to the detail. We don't do that because we believe as lawyers, we have nothing else to do except knowing the provisions of law. We need to go a little more to find out this. We must find out, please give to me the project report which you gave at the time when you were securing for a loan from the bank. What were your expectations at that time? What really went wrong? Why did it go for default? Then tell me now, if you're saying in another 6 months you'll be able to pay, tell me how you'll be able to make the payment in 6 months' time. Where do you find the cash flow happening to you? Where will you avail to yourself additional loan or funding in order that you make it worthwhile for you to produce and then be in a position to repay? Tell me now, if this is all not going to work, shall we think about a sale of the asset where we'll be able to find a buyer ourselves? Imagine a situation of a property coming for sale, and it will not be possible at all for us to be securing the best price at that time. So help a person to find out it's not worthwhile. You should be in a position to help the person decide to even wind up. It will be a good time to wind up if you think you will not end up in more losses, and you will be able to secure the cash out of sale. Then how do you minimize losses? Shall we continue the business with somebody else? Not merely by infusion of fresh capital, by human resources will be able to generate things. Those are or I don't know all that. Shall we look at somebody who will be able to finance, who will be able to help us manage better? Shall we take a management consultant to find out what really has gone wrong? So we'll go into those aspects of what we have not done before. And that is what, if you are a mediator or merely a lawyer, these will be essential. If it's a mediator, we should be able to steer the conversation through. How will it happen? That question at some other time when I was talking about mediation to another group, perhaps, I was saying the settlement is never final without knowing how the settlement would work. At the time when everything is going to be drafted, we just need to take a heave. Now tell me, how is this going to work? That we must do. So that's a very important area of activity for us, which the Sarfaesi Act gives to us. There is literally about 30 odd legislation now, the central legislation, which talks about settlement, which talks about mediation, which talks about other methods of resolution. So believe me, even there, the DRT, the president is there, you should be able to avail the services of mediators, help them, prime them to see how they will approach. Our own bar, the DRT bar is there. They should try to secure additional skills of negotiation for a party. How do you negotiate with a banker? How, if it is the banker, if you are a counsel appearing for the banker, how do I assure to myself that the undertaking which the borrower now gives to me is capable of being complied? How will I be able to secure better management consultation for that person? All those things must be our activity, either as a negotiator, as for representing the party, or as a mediator, how to steer the conversations. Then the enforcement mechanisms of what section 13 says. I said there are 3 things. There must be an existing interest. I said there must be NPA. Then it talks about notice giving, 60 days payment time. And if any objection is taken, these are mere sections, and therefore I will not detain it there. Something which is very important for me, which you should also, I would want you to know, is payment by a debtor shall be before sale, section 13.8. And the right to protect a borrower, a company, case of a company being wound up in such a situation, what should happen? Section 13.4, 13.8, these make references about how a person makes an objection. You serve a notice on that person. And this is what some case law on the subject has been. And the borrower says now, doesn't give a notice, or he gives some objection. He makes some objections and says, now, this amount of what you're claiming is not correct. This some credits of what you should have given for the repayments which have not done, you have not taken. There are several things which are taken. And the section 13 does not contemplate any response of the creditor, the secured creditor, to say, no, I've given all your objections. We have considered your objections. We reject them. We put it for sale, or we are going to take possession. Need not say any reason. If it rejects it, there is not even a provision for appeal there at the stage, because there is a section which talks about. In Madhya Chemicals, if you'll remember, Madhya Chemicals said that there must be some element of consideration by the secured creditor if an objection is given. And that consideration, even if it need not be a reasoned one, it ought to go into the mind of a secured creditor. Now, in a recent judgment of the Supreme Court, which you'll now see immediately, even that has been cast away. It has been diluted now in ITC versus Blue Shores. I'll show to you immediately the citation. And they said now, they've read down Madhya Chemicals and said what was contemplated in section 13 for a secured creditor must examine the objections given. It doesn't say now the present dispensation from the Supreme Court is it may not be necessary. Now, what does the DRT do? So therefore, when it comes to an issue of sale, what is the level of adjudication which you should make? This was again, initial phases were there. The decisions of the Supreme Court now recently will give you some idea about additional duties of DRT. It is just not merely an institution which sees now what is your statement, your evidence, and then an order after some time. How often do you ever find any case being dismissed from a financial institution? How often do you find DRT ever saying now that there is something seriously for adjudication? Never, not too many times. That is because that is the way the Act is structured. The Act does not allow you to take all kind of contentions. It contemplates a quick disposal, a summary disposal. You don't need at all times a full-fledged trial. For instance, in some DRTs, what I know in Tamil Nadu, there is not even cross-examination. It's all assets and affidavit and counter affidavit. That's all. You don't have a cross-examination ever. So therefore, various courts, various tribunals may adopt various procedures. You may not have all that ability to do things or what you can do elsewhere. Then taking possession is probably the most important thing. How to take possession, that comes through some sections which are important, and that we'll see through some decisions. Now, police powers under section 14, I thought requires some special emphasis. I'm seeing now it's 12:20. I'll conclude at 12:45.
So we should complete the subject. Q&A can always be done, because once the concept is clear, then the Q&A one can always look upon himself.
Now, in no time, quickly, in 5 minutes, I'll conclude. Section 14, because these are the areas I thought we need to know some concepts. 14 talks about the police. This is what is the Supreme Court recent judgment, which I'll say what it is, where they say the powers. Imagine that a secured creditor can take possession of the assets, and if he is resisted, he can call the district magistrate, or he can call if it is a metropolitan city, it's a chief metropolitan magistrate assistance, and you will look at things. He has to see whether an affidavit must be given that there is a secured creditor, there is a subsisting interest which is available there, the amount has not been paid, this is the amount which is necessary, I want possession of the assets. Yes, and possession given. How is it to be given? It can employ such force as it is necessary. That's what it says. And in ITC versus Blue Coast, this is the judgment which is said in 2018-15 SEC 99. You must know some parties are big, some counsel are big. I've at all times seen when a judgment I see who is the party, how big is the party, who is the counsel who has appeared. Harish Salve appeared in this case. And this judgment is about ITC taking over assets from some five-star company in Goa. And they were not making payment. And they were obstructed at that time. And whether obstruction, such obstruction is possible. It makes a reference about, because there were issues there. After sale, the purchaser, ITC, was taking the protection of the chief judicial magistrate for taking possession. was only a security holder entitled to take possession, or can even a purchaser take possession under section 14 was the question. Because there had been various views. Madras High Court, for instance, had a view that only if the sale takes place, the secured creditor will still act as a trustee for a purchaser and utilize section 14. That is what they said. Calcutta judgment did not believe so. It said now it is only a security person who holds a security interest can take possession under section 14. So if a sale takes place, you can't invoke section 14. And that is what Bombay also had said. Now, in this judgment in ITC Blue Coast, they said it is not so, because he takes the definition of section 2F, 2ZF, and it says the amendment before it was deciding a case with reference to the definition in 2F. It doesn't talk about a security interest which is subsisting now. It talks about an interest, and therefore it was possible for a purchaser also to take possession. That was Supreme Court judgment. But now the Supreme Court judgment was, although recent of the year 2018, it was making reference to a provision which existed before 2016. Now there is a change in the definition which is introduced section 17 clause 4A. With 17 clause 4A reads like this: any person in an application under subsection 1 shall give an affidavit. That affidavit must give, among other things, clause B, it must, yes, expired soon as it is determined. An application in section 4A, tenancy, it talks about tenancy. Elsewhere under section 14, the borrower is, proviso. This is a definition, this change has come about in section 14(1)(b) in the year 2013. The ITC Blue Coast does not deal with the proviso clause 2. It says now the affidavit must say the borrower has created security interest for various properties, and that the bank or financial institution is holding a valid and subsisting security interest. After a sale, can you say that there is a subsisting interest? So this is an area for, that could still be doubted, which could be contested. Therefore, I thought I should tell the lawyers, this is an area for activity for the lawyers. It's your ingenuity for you to read down ITC Blue Coast 2018 to say that it was a judgment which has not considered a change which has come about in proviso to 14(1) in the year 2013. And then for tenant rights section, there is a 4A which is introduced in the year 2016 that also alters a lot of things, and which we'll see where it takes us, because section 65A of the Transfer of Property Act makes possible for you to make a rental arrangement. It enables a mortgagor to make a rental arrangement. Therefore, if there is a tenancy which is created by the mortgagor after securing a debt for a loan which it is going to obtain, the tenant will be able to resist possession. That is the normal thing it should be, because after all, law allows for section 65A. But over a period of time, the change in law has come about that in respect of agriculture tenancies, because it does not, Sarfaesi itself does not apply, and therefore there's not a problem. But with reference to buildings lease and rent control, or rent control legislation, which allows for protection against eviction, notwithstanding any law to the contrary, such as the Transfer Property Act. Now some changes have happened. Those changes through the judgment, there are with these judgments, I conclude. I'll run through each one of them, some decisions which you need to know. Mardia Chemicals is important for us. If you want to understand Sarfaesi, please take this judgment, 2004 4 SEC 311. Young lawyer, they must be able to read this judgment to understand. The need is, it says under section 13(4), this is what I said. Mardia Chemicals is read down in a subsequent judgment now in ITC Blue Coast. The need to give reasons for rejection of the borrower's objection to possession. Right of redemption is lost by action in section 13(4). The moment possession is taken, then right of redemption is lost. You don't have the facilities of what are possible there. Under Order 34, Rule 5 may not be possible. Now it is preserved under section 13(8). 17 is the nature of a suit. This is important because the provision is under section 17 like an appeal. It refers to an appeal after possession and things. If it comes to DRT can't say, I'm now looking at it as an appeal. Now, whatever has not been done previously, you can't do. It is the Mandia Chemicals explains the action under section 17, which is in the nature of a suit under CPC. That's what it says. There was previously a provision there also under 17.2 that if somebody comes to DRT for a challenge against the order of possession, against CJM declaring a possession, or a secured creditor takes possession directly, which was possible through means of an appeal, it was required to deposit 75%. The court said it was not valid. Section 34 of the Sarfaesi Act read down to allow for challenges for fraudulent sales, because it's section 34 says no civil suit is possible with reference to no injunction is possible, no stay is possible. But then Mandia Chemicals reads it down. Not possible can still be possible if there is a fraudulent sale which has taken place. The civil court jurisdiction will not be taken away. That's what is Mandia Chemicals. Such an objection is possible also under section 17 itself. Obligation as to what sale, how which has taken place, the possession of what has taken place, a non-consideration of an important objection which he had given, which was rejected, and then they took possession. All that can be done there. Matthew Verghese in 2014, this is important for for a reason, that validity of a sale auction process need for fresh notification, because I said there are, like in criminal cases, in NDPS, you have defenses, very little defenses, because the punishment is high. Every technicality is important, because it is notorious fact that sales take place for grossly low values. If you can show that the 30 days notice period was not there, and if adjournment of sale had taken place, and when a sale had taken place more than 30 days after that, a fresh notification was not given, is good reason. Justice Khalifullah's judgment in 2014, 5 SCC 610, makes reference to you to help you understand how important are the rules, the enforcement rules under 8 and 9, how the punctilious observance is so relevant is what this judgment brings about. And state coercive action, Visalakshi, probably that's the latest law that was in 23rd December 2019, Indian Bank versus Visalakshi. It did two things. One, it said, because some courts had taken, there were different views. The different views where there is not a chief judicial, the metropolitan magistrate, then it should be the district magistrate. It can't be any other magistrate in places which are not metropolitan places. Now the courts have said it can be the chief judicial magistrate also. So there, although the expression is the chief metropolitan magistrate / district magistrate, it could be CJM in places where there is no metropolitan magistrate. That is what this section says. Again, there are three ways of taking possession, how it should be done. This judgment is again after section 14 proviso. Already read to you the proviso, and how possession at that time, an obstruction which is given, there is a need for the DRT, if it ever comes to that, for that to see whether objections have been properly taken, was it properly considered, was there something wrong. All those matters can be considered now, because it may seem like some judgments have gone in the way that everything is over, you're there, DRT is there only to make it happen for them. There is no fresh adjudicatory process every time. But rules of natural justice have to be read into every one of these things, and that's why I think it's relevant. And the court's discretion. Now again, in ITC versus Blue Coast, ITC was able to secure everything in its favor. And 226, if you bring a challenge under 226 that the secured creditor or the purchaser didn't do anything properly, and they were testing the conduct of the debtor, and said 226 in the High Court, how the debtor was merely, because that was a case where objections had not been properly considered, and possession was taken. And he was saying, now under notice, under sale took place, and the fourth or fifth auction, the property was ultimately taken. There, they were not seeing that there were some mishaps, there were some small technical glitches, there were not adequate notices and things. I said, no, what was this man trying to do? The borrower is conducted that conduct had been at all times engineered to take time. So what are we seeing now? his conduct had not been good, therefore discretion will not be given. That is how they looked at it, and ITC therefore looked at it completely different. In Bajrang Agarwal, this is for you to know, this has changed a lot of understanding of law relating to a tenant's right to object. Arshad Govardhan was affirmed, and Vishal Lalsaria was partially not accepted. You need to know in Bajrang Agarwal, it is like this. Just state this: a tenant in possession of a property before the security interest, that's not a problem. You can at all times defend and say possession can't be taken from me. Actual possession I will not give. It is not possible. Now, supposing a tenancy is created after the security interest, you'll have to examine it under Section 65A of the Transfer of Property Act. Was it a bona fide transaction? Was the mortgagor making the loan, this tenancy arrangement for adequate and appropriate reasons? But 65A of the Transfer of Property Act is fully complied with. Yes, it is accepted. He can resist possession. If it is after notice under Section 13, if tenancy is created, no objection at all can be given. He has to simply be thrown out. You can't claim any benefit under the rent control legislation. But with reference to anything before possession and after creation of interest, the act, this Bajrang Agarwal makes two distinctions. If it is a tenant at sufferance, so these tenant at sufferance, tenant holding over, these are concepts from the Transfer of Property Act. You will remember the rent control legislation provide for protection against eviction, notwithstanding any law to the contrary. Therefore, a tenant holding over, a tenant sufferance, a tenant does not pay rent, all that is possible. But if he's a tenant at sufferance and he has not paid rent, it can be ejected and possession can be given, notwithstanding the fact that the mortgage, the tenancy was for a valid reason. If he had been and if he had not been paying rent, you don't need to wait till the rent controller orders eviction on the ground of willful default. It is possible for you to displace him here. And if he's a tenant holding over, mortgage has happened, he's a tenant holding over, he's paying the rent, then that objection will have to be seen. So therefore, if there are objections before the DRT under Section 17 as to what these objections are, it can't merely be riding roughshod. I think Bajrang Agarwal gives you in the last paragraph what are the tenants' rights. So I'm sure that will be examined. That is some area for you to act. I conclude now by saying that these judgments, I'm now merely taken things of what are relevant. And tenancy rights, I thought at the time of obstructing possession or the debtor to say that these are all amounts not correctly done. This would require to be examined, particularly in the light of two important decisions. The authorized officer, Indian Bank, probably is the magistrate, chief judicial magistrate must be the party there, versus Visalakshi is one important judgment. Bajrang Agarwal, both of the year 2019 is important. And ITC versus Blue Coast, whether it is valid in the light of some changes which have taken place with the introduction of what has come through in the year 2013 of the proviso, which was not taken note of because it was not necessary for the court to look into it. These are views. There was one question which has been forwarded to me. Therefore, I'll answer the question to what is not asked to me. You can, no more slides. You can take the slides and then give the screen for me because I'll take questions of what have come. I'll take one question. I'll answer. What is to be done with goods which are not charged with bank? Now look at this. When a possession is taken, he has to give goes to CJM, he has to give an affidavit. There is a security interest which is subsisting. So with reference to the asset, it must subsist. Without reference to it, if he is not taking the permission or if he is not taking the assistance of the CJM and he is taking possession, if it is not with reference to an asset over which a security is created, question of taking possession does not arise at all. So therefore, it should be possible for the person to come under Section 17 before the DRT and say, now it is wrongly taken, possession has not been with reference to property at all, therefore this is wrongly done. So therefore, but taken possession during Sarfaesi proceeding along with possession of house as borrower is not available for service, that is not available for service, the service was not done at all. These are surely objections which are possible in section 17, and it's possible for you to be re-put in possession of property. So that is a question which was asked, for which not
probably that is Deepak Mehta, because he had posted me. He's a law officer in the SBI.
okay.
Sumiti Jain. Section 17, where any dispute relating to securitization or reconstruction or non-payment of any amount due to including interest arising amongst any of the parties, namely the bank or the financial institution or asset reconstruction company or qualified buyer. Such dispute shall be settled by conciliation or arbitration as provided under the Arbitration and Conciliation Act, as if the parties that disputes have consented in writing for the same. What is your take on that?
No, I've already explained to under section 11 that it is possible for you to settle. What else? What is my take, because on a security which is to be enforced? I don't think I get that as a question, or is it merely a statement from the person who is?
Probably it goes more like a statement, because next question by Sumiti is again like that. Mr. Sachdeva has given his view. He says section 11 exists in part 2 of the Sarfaesi Act, and it speaks of resolution of disputes between the bank and asset resolutions in relation to the intersea disputes by way of arbitration and mediation. Thus, the process of arbitration/mediation is not available to the borrowers and banks for their disputes. He has answered in that way.
That's why, yeah, that's correct. I would not take a myopic view of things. For asset, it cannot be merely an issue relating to the intersea issue between the bank and the asset reconstruction company. Section 11 has a problem. The security, the whole engineering of this act comes through an enforcement of security. Otherwise, what is there? An asset reconstruction company is also a company which is going to enforce the security. If there is a mediation which any provision talks about, it can be only in areas of conflict. What is a conflict which a bank which is going to experience through asset reconstruction company? It is going to assign it in favor of that. It is going to make possible some money realized from the asset reconstruction company, and then making over that asset, or constituting the asset reconstruction company as its agent. So therefore, I don't really see any type of a dispute between them. I would still think for any activity that results in ultimately a conflict, it can be only with reference to a person who has borrowed, who has availed of a loan, of a facility, whose assets have become NPA. That can give rise to some conflict, and that is how I would read section 11. So I'm sure it's available there for. That's why if it comes before the DRT, it is possible. Even if it does not, then it should be possible for the asset reconstruction company itself to invoke mediation. At the minimum, I would only expect now, 11 is not being used at all. We should at all times try to, the DRT must use it, the lawyers to whom the case is interested must use it, must give a proposal to the other side. You will remember that mediation cannot be thrust on anyone. There cannot be a mandatory mediation, other than the fact that some provisions like Commercial Courts Act require that before a person seeks for enforcement or seeks for a claim to be registered and a case taken, there must have been an attempt at mediation. That is what the Act says. Now, this Act or any other Act does not talk about, even Civil Procedure Code. It merely contemplates through AFCON's falling. The judge only said, now before the issues are struck, please ensure whether the case gives itself fit for settlement. If it does, please put it through. It's a court's duty is what it says. But we don't even take that hint at all. We should volunteer at every case. We should think that there is a problem which I have with the financial institution. I'm not able to pay. Let me wait and pay after 6 months, or let me delay times till the property is sold. It's hopeless. We must try and secure something better for ourselves for the deal. And that is when you are a good counsel. I want you to be good counsel, make a meaning out of it, because COVID is truly the situation which is going to generate a lot of stressed assets. There are going to be so many cases coming before DRT. And if all those cases must be only seen as somebody has not paid, put up the property for sale. He has taken possession, sale taken place, give confirmation. Doesn't work like that. I'm sure there are areas for a discussion like it never happened at any time in the past. That's how I would see Section 11 as being exceedingly relevant in these days after COVID.
Thank you, sir. Just for the participants, we have already a good number of questions on the Zoom group chat. We will not be taking any other questions except what they are already.
Let me see.
Sir,
I'll read to myself from where it goes. Sir, can we please have, no. What is to be done if one-time proposal sent by a borrower is not accepted or rejected by bank? OTP is a manner of setting some kind of a negotiation, isn't it? If OTP is there, periodically Reserve Bank gives various situations for OTP. Perhaps it will come through some proposal from direction, because by themselves banks will not be able to accept a OTP. It's a smart decision. If a bank takes a decision to give it away to asset reconstruction company, if it is taking some money, it can give that kind of a benefit to the borrower also. It is possible to keep its own relation. Supposing 10 crore is outstanding, the bank is prepared to wind it up with some 2 crore received from asset reconstruction company, and then create a securitization and then make it possible for the asset reconstruction company to do. That 2 crore can be recovered directly from the borrower, can it not? It all depends on your negotiating abilities and your ability to convince that your non-payment was on account of genuine reasons, that you are not a defaulter. That is how it is possible. I'm sure it is possible. If they don't accept OTP, try and bargain for it. I'm sure it should still work. And then I'll just pick up at random because too many questions have run through.
Yes,
I took from one.
So you can tell me the name. I will hurriedly read that.
Yeah. I see Siddharth Shekhar says, do the asset reconstruction company fall under the definition of a financial institution? It does not fall under a financial institution. Bank or a financial institution, that which lend or what it is. Under the Companies Act, I'm not too sure, Council, it will not, because by themselves, they are not financial institutions to be understood like that. In what context the Companies Act, if it makes a reference about reconstruction or something, probably it does. In what context you're referring to, I'm not too sure. I would like to believe that financial reconstruction companies are not financial institutions. They are different. Financial institutions are those institutions which lend monies. That's how you must see. Then Rajat Malhotra says, what are the remedies available to a guarantor whose property has been undertaken and sold by bank, but at the same time, bank failed to proceed against the property of the original borrower beyond taking orders from BRT? It's all old decision, Rajat, from Justice Chagla, that right of a secured creditor to enforce against any one of the persons is available, either against the principal debtor or against the guarantor. That it should proceed against the principal debtor. If only there is a failure, you go to guarantor, is never an accepted position in law. It's the liability is coextensive. The fundamentals of the Contract Act is the liability of a guarantor is coextensive, and therefore it is possible for them to enforce like that. This is perhaps again a negotiating principle. You can take the borrower with the secured creditor. If there is a guarantor, you can go to the bank, then negotiate with the bank. And now look, my asset is this. This is not going to fetch you immediate money. This man is sitting on gold. That person, the principal debtor's money will be, it's possible. Shall we do that? If there is a person coming to you as a lawyer, you try and negotiate with the bank. Don't immediately think a defense or go to the court saying that I'm only a guarantor, I'm not a principal debtor. They have the resources to go against the principal debtor. It's a completely wrong defense, because that just does not make it possible. There is a well-known case law. So I don't think that will help, Rajat. And
that is in fact SBI versus Impex 91 Supreme Court, which said that the liability is joint and coextensive, then followed by Justice Singhvi's judgment, which says that liability is joint and coextensive. So a short question by this thing: does the COVID-19 extend the period of 60 days of the notice under Section 13(2)? That is by Bhatesh Thakur.
see, I would understand it like this. This notification of what the Supreme Court says talks about the institution of suits. I can't think of this 30-day notice is getting extended. It is not like that. It is to be for any action, for an institution of a suit, that provision arises, that Supreme Court enables you to have an extended period. But anything else, I don't think the Supreme Court notification is applicable at all. So therefore, if there is a 60-day notice which is to be given, the 60 days period is over, can they take the next step now to possession? Perhaps now that is an area which will be able to say that you have given 60 days, you are taking possession. You should, this period, you don't do that, is when you can probably come somewhere and then take some benefit. You can come probably in an action before the DRT to say it is not possible. So this is unfair. Put it there. My objection has not been taken. You place an objection, because as the law says, there is really nothing for an adjudication. Even an objection need not be seen and taken in section 13.4. That is what is ITC now says. There is nothing which is necessary. It will go. You will have only a right to contend before the DRT and the section 17. That's what it would say. I would think not, that the extension of the period will be available to notices and things. It is only to institution of suits and appeals of proceedings before institutions where the period of limitation will be extended, otherwise not. That is my view. I would like to take this as a point for a contention, because it's not open and shut. I would take a decision. Do we not see another court reverses it? Doesn't mean the first one is wrong. It's another way of looking at it. Therefore, I would want you to push for that boundary, expand the frontier, make it possible. Yeah. You pick up whatever question which you think.
Sir, we will just take 3 questions because we will be running out of time. Akhilesh, we asked, what is to be done if the OTS sent by the borrower is not accepted or rejected by the bank?
It's a simple thing, isn't it? OTS is not accepted, then the next step will take place. You have under section 13, whatever is the procedure which is laid down, they will take at that. So therefore, there is really nothing. We should make it work. The OTS, if it is not accepted, it is only because we don't give sufficient justification, nor do we make possible for a banker or a financial institution to realize that you're very serious about it. Many people think OTS is a manner of extending time and there is no genuineness. You must realize that OTS will not be possible for them unless it comes within the norms which the Reserve Bank of India prescribes. Otherwise, I already told you as to several situations where NPAs themselves accumulate only because of relaxation of norms. And OTS schemes are invariably things which are promoted and which are approved by the Reserve Bank. So therefore, they will not adopt anything which is not there. If OTS must be accepted, it is a matter on a proper negotiated principle. And that is what I would say. You won't have anything. You won't be able to go to court to stop it. You won't be able to go to DRT and stop that if they're taking action. My OTS has not been accepted. It's purely a bargaining point, which you will know is not something adjudicatory at all.
So my personal take is that after Sardar Associates, the RBI guidelines also still say that they are non-discretionary and non-discriminatory. So if the case of the particular person falls within the OTS floated by the bank and the RBI, it has to be accepted in any case. On that point, they can always challenge it.
So therefore, within that's what I'm saying. Within this is again the Sardar Associates. I think it went from Punjab, our court.
Yes, sir.
So therefore,
so probably it was from your judgment only, which while you were holding the single bench.
Correct. And then Bharadwaj say, in case of consortium lending, the account with the lead bank is running fine, but it goes to NPA with one member bank. That member bank wants to sell the property under Sarfaesi, which is mortgaged with the lead bank. In case of successful sale, how would the lead bank handle the account, because it will be unsecured after sale of mortgage property? Yeah, it's a principle which is under the Transfer Property Act. The submortgagee, now what right that he has? There is a prior mortgage which is already there. While a subsequent puny mortgage must always be added, the prior mortgage need not be, prior mortgagee need not be added as all party, for his interest is never lost. So therefore, if it's a consortium of a lender another bank, which is a subsequent to mortgagee, then no matter they take action or purchase, the prior mortgage which existed will not be lost at all. So I'm not too sure about what you're saying. The mortgage is lost, the security is lost. No, it will not be lost. If it is a subsequent mortgage and the prior mortgage existed, and it will not be lost. A prior mortgagee will not lose his interest merely because a subsequent mortgage has been put up for sale. Mortgagee put it up for sale, if I have understood the question correctly. So otherwise, the prior mortgagee loses nothing.
Sanjay Krishan, can an insurance company approach the DRT for recovery of money under the subrogation?
Insurance company, where does it come? Insurance company, where is the question of insurance company making claim under Sarfaesi? Because Sarfaesi can be invoked only by a financial institution or an agent such as a reconstruction company. No one else will be able to come. The latest judgment, which was Pandurang, the Supreme Court has considered, this is the judgment of a 5-member bench. I think Justice Arun Kumar has written the judgment, which was pronounced on 25, that is how many days back? A few days back? 25, or have we not come to 25 at all? Today is 14/5. It's probably I'm making a mistake. It's some 24 probably, where he has said cooperative banks are also financial institutions. I don't see therefore an insurance company approaching DRT or invoking Sarfaesi. It's not possible.
So Mr. IP Singh, who just welcomed you, and the president of the bar, he writes that he had the honors to conduct the case of the Sardar Associates.
Very good. So
last question we will take. Can OTS be extended if defaulter agrees to pay with interest any judgment?
Can it be extended? No, you say it's all there possible there under the OTS. If it is possible, it is possible. Otherwise, it is not possible. I think it is not purely, see, that is what is important. OTS is not something which is a charity by the bank. These are statutory. They're regulatory in the sense that the Reserve Bank of India makes possible certain things. It examines the financial market, it examines the condition, the industrial situation, the stress assets, and then allows for OTS to be extended in a particular way. If there is a default there, it is lost. If they don't accept, it is lost. The acceptance is not in accordance with a particular scheme which has been given by the directives of the Reserve Bank of India. You still have an issue. Otherwise, you have not.
So though we had said last question, but this question I found it interesting. Ashish Gupta says, there is a flat where flat is given in the security and the building has undergone redevelopment. How the bank could sell that property?
This is always there under the mortgage also. If a secured interest, supposing I demolish a secured interest and then put up a palace, say, no, you can't reach the palace. Will you be able to say, any person, this is the security is available. You can't now do anything which can abnegate a security or do something which can create a problem to the person. Therefore, you will take it to such improved state as it is possible. It is there and available there. You have the answers there in the Transfer Property Act itself as to the improvement, the effect of those improvements. You will take possession of all those improvements, and you won't be able to compel the person to pay for the value of the improvements. He takes subject to all the improvements. Therefore, your do not fetter the right of a mortgagee to secure that interest also.
So we will not take any other questions because we invariably don't go beyond 1 hour 30 minutes. So like we have experienced as a lawyer while making submissions before you and otherwise also, how to make grasp on all so subjects along with the judgments? What is your take that the lawyer should do, or the professionals or the students should learn from you? How do you actually inculcate this habit, and how do you come out with all this case law, etc.? Like as a lawyer, we feel that the associates are not working in the right perspective. We are looking upon you as a role model that individually you are looking into all this.
Because I'm humbled by what you're saying, but I'll tell you something. For a long time, I have pleaded along with lawyers that our facilities like the judicial academies must be thrown open to lawyers on a full base, on a continuous basis. The training cannot be merely for judges. The nation demands, as they say, as a music channel says, it expects the empowerment must come to lawyers. Our judicial academies must be open for lawyers. And we should be able to bargain with our chief justices and with our courts to make those facilities available for us. For enlightened judiciary can be only through an enlightened bar. I can tell you, every one of the finest judgments, if I have ever written, it was an account of fine assistance rendered to me through a lawyer. So therefore, now I'm seeing like I've never done. Unfortunately for us, the bar councils, meaning no disrespect to the high office holders, they've not necessarily gone to persons who are leaders of the bar. I see already a person who is a bar council member here and his father who had been, that he is participating. Therefore, I would want the bar council to take this. Now, what has happened across India during COVID is not the judges. How many judges you think have come to the forum to speak? How many present judges, retired judges are? Some courts, I know in Madras High Court, several of the judges are participating actively in all these webinars. Now, the initiative has gone from lawyers, and that is important. And you have done it. Or what has not happened all along, you have already begun. This state of learning, I see now today, Srinivas Raghavan from Madurai sends to me 23 lectures of what have gone through this month, in this month and last month, after this court lockdown it has happened. 23 lectures is no small thing at all. 23 days. And like that, what probably Vikas and Sapan and other friends are doing from Chandigarh is, you have started the education program for yourself. And that is what. And how did I make it? It's only this. I had some little problems of my inability to sleep, and therefore I could sublimate my inabilities to other things. But even otherwise, I had an interest. My father, he died at 93 years. And after I came in practice, after some 3-4 years, to stop practice. But till he died, you take up, you'll come to my chamber, you'll pick up the latest journal, you'll sit, read, and then tell me during dinner time or lunch time, how is the judgment correct or how is it not right. Discuss with your friends periodically. Critically examine every judgment. If I'm saying ITC is not correct, I would want you to probably not say that in court, this judgment I'm citing is not correct. It's not the way. We should discuss, create this atmosphere where there is an occasion coming, you should be able to push the frontier. That kind of an interest, active interest, you've already started. Don't let this momentum go down anyway. You've already begun. And
so your words are well taken. In fact, as you were pinpointing, sir, yesterday we had Justice Madan B. Lokur and Justice S. Muralidhar on our platform. And we had taken this point that the lectures and all these materials which are given to the Judicial Academy, that should be at least be made available on the YouTube, etc. That point was well taken, and we are quite sacrosanct that at least we will be having the videos just like we have uploaded our videos on our channel on Beyond Law CLC. So another point we just wanted, like while you were just informing us, a point well taken that you were having less sleep, but you utilize it for the purposes of better education. And same is in our case. During the lockdown, we thought that one way was just watching TVs or chatting on the Zoom, etc. with our friends. Another way was to latch upon the opportunity and create something. And we are quite happy. Like yesterday, we had an audience and participants that is on the platform itself, 990. Though we are also going live as on today also on the Facebook. So what is your take to the young lawyers? Do you feel that, and students, that Securitization Act would itself be a good platform by solely relying upon this field to develop their professional practice in this?
Extraordinarily, it's possible, because I expect now there is a boom of litigation under Sarfaesi and before DRT. Mr. IP Singh will be suddenly seeing a lot of cases on his board, and we should help him sort out things. And I would expect also Mr. IP Singh to be looking at lawyers' assistance to see how reconstruction of debts, rescheduling of debts, all that is done in a way which is possible only to be properly steered through a person who is the president of that association. Young lawyers will be able to see, and this they must take as an occasion to understand a whole system of banking. Just don't go there. Like I said, there is so much to understand. If you are looking for expressions of the financial market, of what exists, extraordinary. Go through these sections one after another. You'll find that there are so many areas which we have never known. Beyond understanding security as that which is created through a mortgage, we don't understand other things. How is the whole system of securitization operate? How do these reconstruction companies work? All that are interesting areas, and that they read, they associate themselves. For a young lawyer, it offers a great opportunity to expand. Probably you'll be looking for financial market, stocks making profit. It expands a horizon in way which other branch of law perhaps does not. So therefore, I would not want anyone to be a specialist to be a young lawyer. I wouldn't want him to be completely associated himself only with Sarfaesi and say my work is DRT and that's all. That's wrong. As a young lawyer, you must have his interest in CPC, IPC, securitization and everything else. At some point of time, you can specialize. But then there is a lot of activity which will happen in this area. And I'm sure young lawyers can learn a lot and do a lot of work.
It's a point well taken. And sometimes during my career of 25 years, I've also seen that there is a drastic change in the act. And you certainly find, just like when the DRT Act came in 1993, the lawyers who were practicing on the civil side and were the bank lawyers basically, or defending on the borrower side, they just were flowed down because the entire proceedings had shifted to the DRT. So, and thank you for all the insights. And before I ask formally from Shikha Dheman, assistant professor in UILS Punjab University, who are partners in our webinars, propose a vote of thanks, just informing the participants that tomorrow we have Honorable Mr. Justice A.K. Sikri, former Judge, Supreme Court of India, to give us his insights on proportionality, balancing the scales of justice. He will tell us how this doctrine of proportionality will be utilized for the purposes of criminal law, civil law, and service law. Do stay connected. Do stay connected on the Facebook and Instagram page or on the WhatsApp group for the latest updates. Over to you, Shikha Dheman, on behalf of ULS, to propose a vote of thanks to Justice Kannan. And Justice Kannan, it was a wonderful session. Thank you for all the insightful, and we are all enamored by the way you expressed it. And you just had us woven all across for this 1.5 hours. We didn't even realize that the time is over. Thank you, sir. Over to Shikha.
Thank you so much, Vikas, sir. A very good afternoon to one and all present here. It's my privilege and honor to propose a vote of thanks and acknowledge the contribution made by Justice Kannan on today's webinar. On behalf of Beyond Law CLC and University Institute of Legal Studies, Punjab University, Chandigarh, first of all, I would extend my most sincere thanks to Almighty for making this webinar happen in such a situation when our country is facing a crisis. Now, I would extend my heartiest thanks to Honorable Mr. Justice Kannan, who has been kind enough to share up his academic as well as practical knowledge and spare his valuable time with us. Sir, today we had an opportunity to hear your thoughts on security enforcement under Sarfaesi Act, which have actually enlightened our minds. Your Lordship have been beautifully tailoring his entire lecture for the audience by articulating upon the historical perspective of the Act, analysis of its different provisions and concepts, its judicial approach as well, thereby making us very, very crystal clear about the complex and tedious issues of the Sarfaesi Act. So your well-structured lecture justifies your immense knowledge on the topic, and at least for me, it has cleared so many points. We'll be looking forward for such more lectures sometime from you, sir. Thanks a lot. I am immensely thankful to Mr. Vikas Chatrat also for his efforts towards anchoring today's session. Also, we have been fortunate enough to be backed by a team of very proactive and dedicated members for conducting this webinar. And lastly, of course, my sincere thanks to all the participants for maintaining decorum and making themselves a part of this interactive session. Once again, I thank you all for your kind attention. Stay safe, take care. Over to you, Vikas, sir.
Thank you, everyone. Thank you, everyone. Stay blessed and stay safe. Thank you, everyone.